Hi, everybody. Pete Sartes for the lawyer you know. The Elizabeth Holmes sentencing memorandums have been filed, and today we're going to take a deep dive into the defendant's plea for leniency and the government's response. But before we do that, as always, if you enjoyed this video, please give me a thumbs up. If you've enjoyed this series or any of the other cases that we follow here on the lawyer you know, please subscribe to our channel. And as always, leave me questions and comments below. Okay, before we get into the Elizabeth Holmes sentencing memorandum, what I'd like to do is talk about Sonny Balwani just for a moment. Things have happened in his case. The defense has filed a motion to continue his sentencing. The main reason is that the federal rules require that the defense have a copy of the pre-sentence report 15 days prior to the actual sentencing. And apparently that has not happened in the Sonny Balwani case. Therefore, the court is obligated to push that sentencing out. It has been rescheduled for December 7th. We will keep you up to speed on what's happening in that case as events materialize. But for now, let's talk about the plan for the Elizabeth Holmes sentencing memorandum. All right, let's talk. Number one, I want to go through the defendant's sentencing memorandum first. It is 82 pages long. I'm going to show you some snippets of it. There are portions that have been redacted from the record, at least from the public view, because they discuss the actual sentencing guidelines, calculations by probation, which are in fact confidential. So you'll see a lot of sections have been redacted from the public document. We'll talk about what the defense is arguing and kind of the way that they placed this memoranda in front of the court. And then, presuming that this is going to take as long as I think that it is, we are probably going to do a second video regarding the government's response, because that is also a very lengthy reply to the defense sentencing memorandum. So I'm gathering this is going to probably be two videos for those of you that really want me to get into the weeds on these sentencing memorandums. Now, for those of you who just want to kind of get a general idea about what's going on, don't worry, I've got you covered. We will talk about what the government's request is for sentencing. We'll talk about what the defense has asked for. And I can glean just from the pleadings what the probation office has scored Elizabeth Holmes and what that recommendation is going to be. So we will talk about those things early on. And then if you don't want to listen to the rest of it, that's fine. Those of you that want to dive into this with me, we're going to have plenty to talk about today. All right, let's get into it. The sentencing memorandum that was filed by the defense is really long. And my initial take of this is there's a good amount of substance, meaning there are laws, statutes, rules, things that have been cited by the defense, which make this thing a good legal document and have some meat, it has some meat behind it. There's also, in my opinion, a very good empathetic portion of this this sentencing memorandum, and that really deep, personal, empathetic side, I think, really comes through here. A lot of stuff is attached to the sentencing memorandum. There are 130 character reference letters attached. In some previous videos, excuse me, we talked about how kind of the defense will put together a memorandum asking the court for leniency. And this is exactly what this is. And I think the defense team has done a very good job. Let's talk about it. But before we do that, let me actually show it to you so you can actually follow along with me. This is the sentencing memorandum. As you can see, it is document 1642 in the case file. So if those of you that are actually following the docket, you can find this document and you can read all 82 pages for yourself if that's what you wish. But we are not going to do that exactly. I'm kind of going to move around to sections that I think are relevant for our purposes to kind of get a flavor of what the defense is asking the court to do and why. All right, let's kind of get through the table of contents, and you can see some of the redactions that have happened that cite the actual pre-sentence investigation report. Table of citations, you'll see all of the cases that the defense cites. Here are the statutes and the rules and some additional authorities that are relevant, including 50 Shades of Grey. No, I'm kidding. These are talking about sentencing trends in white-collar cases, but I thought that that was a cute title for that particular publication. So you'll see a lot of that's here. And let's start with the preliminary statement. This preliminary statement basically says the following, and I'll kind of paraphrase it and get it down to the nitty gritty. We all know that Elizabeth Holmes was convicted of conspiracy to commit wire fraud and 3 counts of wire fraud respect to sophisticated investors. And that's kind of important because the defense is making it clear right off the bat that these are not average people. These are not, working folks. These are sophisticated investors that are involved in this case. They obviously are treated differently than, average Joe or average Jane investors. So Ms. Holmes was 19 when she founded the company. It was her first business experience in 2010, and this period began a chapter where she basically ran Theranos from the ages of 25 until she shut the company down in 2018 at the age of 34. She worked tirelessly along with hundreds of brilliant and committed employees to improve access to affordable health information. The company achieved incredible, valuable inventions for which the United States government is still issuing patents as recently as July of this year. She suffered substantial trauma throughout the time period of this offense. She never cashed out. She went down with the ship when the company failed, and for the rest of her life, she and her family will be punished, as her partner knows too well, because Billy Evans has said there is no avoiding the scorn that accompanies Elizabeth Holmes. The preliminary statement continues by saying, among the countless people in our society who do not know Elizabeth Holmes, yet think they know about her case from the unusually intense media coverage of it, Miss Holmes has become a caricature to be mocked and vilified. 130 individuals who actually know Miss Holmes have written to the court to help in this process. Among them are friends, family, Theranos investors, Theranos board members, and former employees who served in a variety of roles at Theranos, all of whom submitted letters despite the risk that they will be criticized for their support. Let's continue here. I like this part, and this is very interesting. Listen to how this reads. The real Elizabeth Holmes is a compassionate friend who is there for the people around her to support, comfort, cheer on, problem solve, and connect. The real Elizabeth Holmes is the friend who writes letters that I still keep and read again anytime I need to be reminded of my purpose and inner strength. The real Elizabeth Holmes is a devoted mother who turns ordinary moments into magical experiences of unbounded love and wonder for her son. The real Elizabeth Holmes is extremely genuine, giving, and selfless, unlike anyone else I've met in Silicon Valley. The real Elizabeth Holmes was an approachable, attentive, and supportive employer and focused CEO. The real Elizabeth Holmes faced the challenges at Theranos from 2016 to 2018 with steadfast ethical principles, complete dedication to what was best for Theranos, and admirable courage. The real Elizabeth Holmes is driven by a single and simple purpose. She wants to make the world a better place than it would have been without her. The real Elizabeth Holmes has within her a sincere desire to help others, to be meaningful. Let's try that again. Has within her a sincere desire to help others, to be a meaningful service, and possess the capacity to redeem herself. So that is basically the argument that the defendant is going to make at sentencing, condensed in a nutshell. The real Elizabeth Holmes is different than the person that we see in the public, in the media, in the press, in the TV shows. And that is what the defense is hoping the court will focus on. I just hope that the defense recognizes that the court probably hasn't watched all of that Elizabeth Holmes media, since he's in fact presiding over her case. And the only feelings he has about Elizabeth Holmes are formed during this trial and during the proceedings that this case, again, has been in front of. So let's talk about it. So Section 3553, again, this is the portion of the sentencing guideline that requires a court to fashion a sentence sufficient but not greater than necessary to serve the purpose of sentencing. if a period of confinement is necessary, notice that statement, if the defense suggested a term of 18 months or less with a subsequent supervised release period that requires community service will amply meet that charge. Let's talk for a second about why that is important. In other words, the defense is asking for 18 months of incarceration if the court decides that incarceration is necessary in this case. That number is not haphazardly selected. Let me tell you why they picked 18 months. First of all, from the Bureau of Prisons perspective, any sentence less than a year normally will not be served within the Bureau of Prisons. They will normally let that person serve their sentence in a state holding facility that the Bureau of Prisons contracts with. In other words, a local county jail. Probably the worst way to do your prison time, especially as a federal inmate, because obviously the county jail is really not the place you want to be, because there are people that are there for all sorts of things, to include violent crimes, to include drug offenses, all kinds of offenses that are outside of the norm for federal prison, especially with someone who very well is going to be sentenced with a bunch of white-collar offenders. So that 18 months is a purposeful request. Anything, again, under 12 will be served outside of the Bureau of Prisons. Now, the Bureau of Prisons generally will provide about 20% of a sentence as good time or gain time. And what that really means is you serve about 80% of your sentence when you go to federal prison. So what is 80% of 18 months? 12 months. The next thing you should know is that the Bureau of Prisons normally places people back in the community within their last year, or at least within the last 6 months of the sentence they're serving. I'll say that again. The Bureau of Prisons, for the last year or at least the last 6 months, will send inmates to either a halfway house, to home detention, to a place outside of actual prison to get them back into the community. So in essence, what the defense is asking for is house arrest, because an 18-month sentence actually means 12 months. And if the Bureau of Prisons releases people somewhere between 12 and 6 months from their sentence to outside confinement, that means the defense is asking that the court basically give her home confinement and a term of supervised release in the future, which basically means community service. We'll see how that goes. I'll do a spoiler. The probation office has indicated that they believe that 80 years is the total guidelines sentence, which is level 43, basically off the charts. The statutory max is 20 years. They have suggested an 11-year downward departure. So they're actually asking the court to issue a sentence that they believe is fair of 9 years. The defense now is asking for 18 months. And I'll share with you the prosecution is asking for something more in line with 15 years. And we'll talk about that when we get to the government's sentencing memorandum. So let's kind of continue our way down here into the sentencing memorandum and talk about what is going on here. The defense starts with Holmes' personal history and characteristics, and they talk about her childhood, talking about living and growing up in Washington, D.C. and Houston, Texas with her brother Christian, who is 2 years younger with her. Her parents were both public servants. Her mother, Noelle, worked on Capitol Hill for members of Congress and committees in the House of Representatives. Her father, Chris, spent years working as an environmental protection agency agent in the United States Agency for International Development and the State Department, focusing on issues related to disaster relief. Chris, who is Miss Holmes' father, was her personal hero. And when he came back from working abroad, he would share stories with her about responding to disease, genocide, war, natural disaster, and imparted the view that the most important thing he could do in his life was help other people. The defense continues that kind of early development for Elizabeth Holmes by talking about that this is the time where Holmes learned the lessons of stoicism and sacrifice in the service of the greater good, and she took them to heart early in her childhood as a foundational trait. Then there are things that are redacted, which I don't know what they are. She naturally was curious and had a deep hunger for knowledge. As a teenager, she poured that curiosity into schoolwork and extracurriculars, such as spending part of her Saturdays taking Chinese lessons from the time that she was a preteen. She was driven and goal-oriented and thrived in whatever she set her mind to. During her sophomore year, Liz is how they refer to her, led efforts to help victims of the Kosovo War. A world away from Houston, she organized similar campaigns for other causes, including the Turkey earthquake relief. She immediately started contemplating how she could help and took action developing a plan to work with major software companies in the United States to provide software to schools in China at a low cost. Miss Holmes also was a source of support with her own family. Her father described how when Enron collapsed during Elizabeth's senior year of high school, he lost his job, his savings, and his health care. And during that time, Elizabeth was not just his daughter, but she was a wise friend and helper. Let's see here. Let's talk about college. The defense tells the court that Ms. Holmes focused on chemical engineering with an eye towards combining several engineering disciplines. She brought those difficult classes, her deep work ethic, and sound moral compass. Actually, it says she brought to those difficult classes her deep work ethic and sound moral compass. Ms. Holmes started auditing graduate level courses and worked in the laboratories of Professor Channing Robertson, where she was part of a team developing microfluidic sensors. Her friends in college described her as a caring person who believes in the genuine goodness of people and loved to talk about her ideas. She was full of vibrancy, curiosity, kindness, and warmth, extremely intellectual yet unpretentious, and always looking to better herself and those around her. Here's where we kind of walk into the dark side of what we know of Elizabeth Holmes' college life. While fraternity boys puked on carpets and tried to coerce us into endless games of beer pong, says one of her friends, Elizabeth whispered in the corner about things like philosophy, psychology, consciousness, and the meaning of life. The summer following her freshman year at Stanford, Miss Holmes interned at the Genome Institute in Singapore. During her Stanford autumn quarter, which began in September of 2003. Less than 2 weeks into that quarter, Miss Holmes attended a fraternity party with some of her sorority sisters. While intoxicated and initially unconscious, she was raped by a friend who was a member of one of the Stanford-affiliated fraternities. Following the rape, Miss Holmes experienced acute self-blame, isolation, and depression, and struggled with suicidal thoughts. Interestingly enough, there is a redaction of sorts here, probably talking about who said this. So whatever that person's name is said, her demeanor instantly changed. Her brother observed that after the assault, she became more withdrawn, less social, and more focused on the next venture. After her rape, she was both broken and resolute, using her anger and hurt as the impetus to make the change she strongly believed in. Rather than seeking to heal, she came to view the assault as a crucible that would help drive her work as she turned to the higher purpose of helping solve difficult healthcare challenges through the company she was forming. After the winter quarter of 2004, Ms. Holmes chose to take leave of absence from Stanford to focus on building her company, which ultimately became Theranos. All right, so the defense in the next section talks about Elizabeth Holmes as CEO of Theranos. She learned how to navigate the complex world without the benefit of completing college, studying for a master's in business administration, or obtaining years of industry experience like most CEOs. She relied instead on her personal determination, her advisors, employees, and lessons learned from her own mistakes and successes. She served as CEO for the company from its founding until June 2018, when she was indicted. Though she lacked business and management experience, Ms. Holmes brought to Theranos the qualities she had developed in her childhood, a deeply held interest in improving lives and doing good. An unmatched work ethic, a creative mind, and willingness to learn, in kindness, compassion, and gratitude. Miss Holmes recognized at least some of her limits and sought out advice from those who could provide the expertise that she lacked. Sonny Balwani was one of them and became her most important advisor. Miss Holmes was very good to acknowledge where she did not have expertise, but also respected when she didn't have and referred to those who did. Over the company's life, it had hundreds of employees, dozens of scientists and engineers with PhDs, MDs, and master's degrees, employees who had previously worked at medical device, pharmaceutical, and software companies, manufacturing personnel who worked on machinery, injection molding and assembly, experienced marketing personnel, in-house lawyers who had worked for major law firms. Theranos also hired outside law firms, including Wilson, Sonsey, Boyes and Schiller, and Hyman Phelps for corporate intellectual property and regulatory work, outside accounting firms, a leading laboratory consultant to help start and advise on Theranos clinical laboratory, and outside marketing firms. So why is all this here? The reason this is here is that the defense is priming the judge to be able to argue she's a kid, she's a college dropout, she is not someone with an MBA, she doesn't have corporate experience, she's a kid, and this is a kid with amazing vision and ability who surrounded herself with the best of the best with honors. To quote some movies, I might do that in this episode. And these people had PhDs, MDs, master's degrees. They were experienced. They were seasoned in their own areas of expertise. And she, meaning Elizabeth Holmes, relied on them for the things that she did not know how to do. And I think this is where we're coming into for the defense preparing the judge for them to say it wasn't her. It was everybody else. It was Sonny Balwani, but it wasn't her. And if it was her, all these other people hadn't figured it out either, so she shouldn't be held responsible. So let's continue. Let's see here. Yeah, they continue. Holmes was a visionary without a college degree who was learning how to CEO, but surrounded herself with employees, directors, advisors, mentors, and consultants whom she believed had the right experience to make Theranos successful. All right. Elizabeth came to the office every single day with a highly engaging and positive energy. She listened intently and internalized the message for further processing. She may ask clarifying questions, but never interjected biases or defensiveness. And if it's not clear already to you, I'm actually citing the quotes from all of the 130 letters of character reference that are included with this sentencing memorandum. Former Theranos employees observed that Miss Holmes genuinely cared about the people she worked for, scratch that, cared about the people who worked for her company. All right. Miss Holmes did not build Theranos for nefarious reasons. This is important. Indeed, the opposite is true. The company's mission was to provide access to actionable health information to improve human health on an equitable basis. All right. The defense is priming the judge for a different issue. The issue being that there was no intent to commit fraud on the part of Elizabeth Holmes. And again, this is going to be important for when they start talking about the sentencing guideline calculation, dozens of pages from here. Let's continue with their thought process about why this is important, because they say Miss Holmes did not personally profit from the investment of others into Theranos. Those investments were used to pay for research and development on groundbreaking innovations and the company's operations. Although Miss Holmes was touted as a billionaire in the media, her purported fortune was entirely on paper based on the Theranos stock she owned. She never cashed in that ownership. In fact, she never sold a single share of stock, despite the opportunity to do so at several points over the years. In the 2015 timeframe, Miss Holmes was offered the opportunity to sell hundreds of millions of dollars in her stock holdings in Theranos. She turned down that opportunity because she felt that she should not profit until all of her investors had returned their investment profitably. Again, pointing to the fact that there was no intent to commit a harm on the part of Elizabeth Holmes. Near the end of the company's life, she volunteered even to give up her ownership of the company in hopes of saving it. All right, let's talk about the relationship with Mr. Balwani. We knew this was going to be in the sentencing memorandum. It is impossible to understand Ms. Holmes' experience, say the defense lawyers, at Theranos, and particularly with respect to the offense conduct, without closely examining her relationship with Sonny Balwani. We're going to be throwing Sonny Balwani under the bus here. In the wake of her rape, see here, around the time that she was considering leaving Stanford, Ms. Holmes reconnected with Mr. Balwani, a person she had met after graduating from high school on the Stanford sponsored China trip. She was 18 and he was 38, definitely demonstrating here how much older he is and how much authority he is going to have over her. She understood that he was a successful businessman who had built and sold his own company and had worked with Microsoft. She viewed him as a potential advisor and mentor during that summer. They began a romantic relationship. That relationship between Ms. Holmes and Mr. Balwani was characterized by severe emotional, psychological, and sexual abuse perpetrated by Mr. Balwani. Mr. Balwani demanded that Ms. Holmes follow a series of prescriptions, including keeping a strict schedule with little sleep, limiting her from food intake, refraining from alcohol, and maintaining a particular manner and personal style. Mr. Balwani prescribed tenets for Ms. Holmes to follow, which he wrote for her. Holmes was required to write out her schedule regularly and confirm her commitment to his teachings. Sounds a little helter-skelter to me, but that is the representation that Elizabeth Holmes' lawyers are making to the court, that basically Mr. Balwani groomed her and was actually using her as a puppet. Mr. Balwani also insisted in the form of verbal and written beratings that Ms. Holmes was incompetent, fundamentally flawed as a person and a leader, and needed to change who she was. Nope, too much, sorry. Here we go, sorry about that. Words kill the current Elizabeth Holmes and become a new one and a worthy leader. Ms. Holmes' assistant from 2014 until 2018 confirmed in her letter that Mr. Balwani would constantly go into her office, shut the door, and kick out whomever was in her office. He would then scream at her. I could overhear the screaming, obviously to support the fact that Mr. Balwani was a violent presence for Ms. Holmes in the office. All right, let's continue. The dynamics, such as these, are common in abusive relationships and especially effective at creating a culture of control. Again, we're going to blame Sonny Balwani for everything. I'll kind of walk through this. Mr. Balwani's abuse involved the severe sexual elements that caused Ms. Holmes particular distress, including thoughts of suicide. These even occurred in the home they shared. Again, there are some redactions here, and I'll continue on. The severe abuse Ms. Holmes suffered at the hands of Mr. Balwani affected her deeply, including in her role as CEO of Theranos, i.e. the person that was convicted of fraud, not the real Elizabeth Holmes. At Theranos, Mr. Balwani took primary responsibility for operational aspects of the company that included preparing the company's financial statements, meaning I didn't lie about the company's financials, including revenue and revenue projections, managing the retail partnership with Walgreens, meaning Elizabeth Holmes didn't lie to Walgreens, overseeing operations of the clinical laboratory, meaning Elizabeth Holmes wasn't in charge of the laboratory that was producing falsified results or fraudulent results, as well as maintaining operational and general matters. Mr. Balwani was responsible for following up with potential investors. After an initial meeting, he was the best person to answer questions about Theranos' financial model and projections, as well as operational issues that are often the topics of due diligence request, meaning that Elizabeth Holmes didn't lie to the investors. Sonny Balwani lied to the investors. Let's continue and talk about Miss Holmes' current family life. All right. The defense tells the judge that Miss Holmes has been dating her partner Billy Evans started dating him, in the first half of 2018. Mr. Evans and multiple friends who have submitted letters described their initial hesitation in befriending Miss Holmes once they realized who she was and how the woman they came to know, despite their trepidation, was a gentle and naive, hopeful, loving, humble, patient, and dedicated beyond what most people have ever experienced. So, not a conniving, backstabbing fraudster, but a gentle and naive, loving person. Continues, she's a hands-on, loving, and attentive mother. Obviously, we know that goes to a reference to her current son and obviously the baby that she is currently pregnant with. Continuation, they talk about her volunteer work. Very reasonable for a sentencing memorandum. Pay attention to this section. Ms. Holmes became certified as a rape crisis counselor and advocate and has spent over 500 hours volunteering in support of sexual assault survivors, including victims of domestic violence. That work includes scores of shifts managing recently launched statewide helplines. She has worked with a variety of callers, including calls with actively suicidal victims of sexual assault, calls with community professionals, and calls to local law enforcement and or the Division of Child and Family Services when necessary. All of this happens after her conviction. So none of these things did she do prior to being convicted for fraud. These are things that happened after she was convicted for fraud. And I'm not characterizing the good works, and I'm glad that she's doing good things. But let's just be clear, this is not stuff that she's done before she needed to tell a judge what a good person she was. The organization that reports, the organization that she works for, reports that Ms. Holmes had worked on assisting with the compilation of sexual assault and domestic violence resources statewide for callers, as well as identifying gaps in resources that were available. So obviously taking not only a personal interest in this volunteer work, but also trying to better it and basically taking a management function of it. I think that's going to sting a little bit when the court reads this. All right. They continue, personal characteristics. Let's talk about who Lizzie actually is. Ms. Holmes has been the subject of a caricature in extensive and intrusive media portrayals, whether the portrayal is couched as a nonfiction book or a fictionalized dramedy. I guess that means a comedic drama. Those caricatures presented by people who do not know Ms. Holmes are strikingly false, as the scores of people who actually know Ms. Holmes make clear in their letters to the court. One of them says, I've been taken aback by just how dramatically divergent the fictional character of Elizabeth Holmes presented in the media is from the entrepreneur, woman, partner, mother, and friend I have come to know and care about. Again, pulling at heartstrings for a court that most likely has refrained from media coverage of this case, but I digress. Let's see what else they go into. The collection of letters attached to the sentencing memorandum paints a consistent picture of Ms. Holmes as a compassionate, generous, optimistic, honest, and thoughtful person. Again, 130 letters from friends, family members, people that she has worked with, board members, all kinds of folks. They go into talking about Elizabeth Holmes' intent to make the world a better place. Friends, family, and coworkers and advisors from all facets of her life consistently emphasize Miss Holmes' intent to make the world a better place from the time that she was a child to today, and talk about projects she has pursued to do. And they actually go through a list of what the former employees actually say that wrote letters. She's a driven, single and simple purpose to make the world better. And this is an overarching theme over the course of the next few pages in this section. She's also a caring and reliable friend. Liz is the go-to person for so many that are dealing with life's hard moments. Again, a number of quotes from the 130 or so letters from these folks talking about how she's a good friend. Advisor and mentor. Consistent with Ms. Holmes' desire to help others and make a difference, she makes time to mentor and advise others, whether in reflecting on and sharing her own mistakes and lessons learned. That is a plea for acceptance of responsibility. They've never, as a defense, accepted that Elizabeth Holmes was liable for anything. And in fact, in a good portion of the sentencing memorandum, they put the blame on everyone else, but they know they need to at least check the box for acceptance of responsibility, because it is something the court can consider to reduce her sentence. So obviously these are the portions, the little tidbits that talk about accepting responsibility in the form of Elizabeth Holmes mentoring and sharing her shortcomings with other people. All right, let's continue. Intelligent and visionary. Okay. Theranos advisor and board member John Moali views Miss Holmes as the most intelligent person he's ever met. The depth and breadth of her brilliance cannot be overstated, and perhaps more importantly, should not be overshadowed by mistakes she has made in the business environment, i.e., perpetrating a fraud and stealing hundreds of millions of people's dollars by false pretenses. All right. Number 5, she is a positive impact on others. This is true for her friends as well as her friend Lauren Statt, who puts it, she learned the hard way and challenges those around her to grow and learn as well. Again, a check the box to say that this is not a part of her life that she planned. This is something that has happened to her, not because of her. When I say this, I mean the whole Theranos saga. All right, let's get into a really heavily redacted section. This is the sentencing guideline calculation that the probation office has come up with. As you'll see, it's a number of pages, and this is where the defense talks about what the probation office is recommending and why they don't agree. For those of you that are following along, I'm going to take you down to page 30 and talk about some things generally. Loss must be proven by clear and convincing evidence. Yes, this is in fact the law. The government has the obligation to prove the loss that Elizabeth Holmes is either responsible for or intended to commit, and that is the law. Everybody agrees with that, and this is a section kind of setting that out. The next page talks about each investor and associated loss must be considered separately. Well, there's going to be a fight on this. The government is going to claim that each investor was duped by the same conduct that she committed in the company by falsifying results, by giving them bad information. The defense's position is that every single one of these individual investors must be considered on their own to determine which ones of them were in fact defrauded and which ones of them invested knowing that there was a huge risk and they may not have known A, that there was a fraud, or B, knew it, realized that there was a substantial risk of losing their money but didn't care. So that's kind of where they're priming the judge for these arguments that they could potentially fall into during sentencing. By the way, they've got the whole day planned for sentencing starting at 10 o'clock in the morning Pacific time for these arguments. So we'll continue. Again, page 32 talks about this, talks about how the investors were broken down. Page 33 continues. Let's get to page 34 to get some meat. Investors expressly acknowledged at the time of their investment that the opportunity was a unique one and speculative in nature, that there were serious risks of investing in the company, that financial projections were speculative and unreliable, and the investors were themselves sophisticated actors. It cannot be assumed that all these sophisticated, wealthy investors who knew about these risks but proceeded to invest anyway would say that they relied on projections they previously affirmed in writing were inherently speculative if they received financial projections at all. As recent events have revealed, the reason why sophisticated investors invest in an enterprise may have nothing to do with the representations made by the company and instead are driven by the vibes and grievances than due diligence, more by vibes and grievances than by due diligence. What they're saying here is this: these are not normal people. 401ks weren't lost in this venture. These are rich people that are very savvy. They invest in things that are potentially very risky because they're looking for those big multiples. I mean, they're looking for returns that are huge. They realize that the financial projections aren't worth anything, and they're basically investing in the vibe of the company. They're investing in Elizabeth Holmes. They're investing in the fake it till you make it more so than the actual real numbers and the real facts behind these cases. They actually cite a Elon Musk report that The Atlantic did, which is a publication back in 2022, talking about how these investors actually invest in companies like Theranos or Enron or Tesla, for that matter, at least in its early stages. So again, the defense priming the judge to say that these are rich people. Don't believe for a second that these people were duped. Continuation, again, some redacted sections. The entirety of each investment is not an appropriate measure of the loss. You know what? I will share with you that I agree with this section. I do believe, and we've talked about this even in my calculations early on, I believe that the loss amount in corporate fraud, when we get to these huge numbers, it does in fact overstate the severity of the crime. And it's reasonable to say this because if you were to look at the sentencing guideline, we've talked about this a bunch of times, Elizabeth Holmes scores off the chart, meaning her conduct, based on the numbers alone, mean that her prison sentence is beyond what the sentencing guidelines was ever designed to consider. So I will agree with the defense, at least in this portion, that this is an absolute accurate section. I'll tell you, the government agrees with the defense, and so does the probation office. I think everybody agrees that the sentencing guideline of 80 years capped at 20-year statutory max is more than is necessary to measure this offense. So let's continue and talk about what is relevant here. Theranos developed a highly valuable intellectual property portfolio over time. As of the second half of 2017, the value of the intellectual property was assessed by multiple outside parties to be at least in the hundreds of millions of dollars and potentially over $1 billion. In 2017, an outside law firm, Perkins Coie, performed an analysis of Theranos' patent portfolio to see if there was an opportunity to use it for licensing and whether the portfolio had significant value. The lawyer who led the charge explains the breadth of the portfolio in both numbers of assets and different technologies. The team discovered that Theranos had more than 1,200 patents across the globe, and a vast number of patents in the Theranos patent portfolio were directed to inventions other than the testing machine, meaning other than the Edison machine that was the focus of this trial, to include real-time influenza detection and patents that solved technical problems relating to aspects of blood testing. Why is this important? Because what they're saying is when you take Theranos as a company, there actually is a part of the company that is financially viable, and that number at some point was valued at the hundreds of millions to billions of dollars for assets that were outside of the scope of the fraud alleged in this case. That's why that is there. Meaning the loss amount should be substantially less than the top of the limit, which is $500 million or more. Let's continue. All right. Theranos also had hundreds of millions of dollars of cash on hand. Several months after the alleged fraud was revealed, on April 17th of 2016, 6 months after the Wall Street Journal had begun publishing articles on Theranos, and 2.5 months after CMS, the Center for Medicare and Medicaid, reported on Theranos' laboratory became public, Theranos had $367 million in cash on hand. After Walgreens announced it was terminating the relationship with Theranos in June of 2016, Theranos still had $334 million of cash on hand. Why is this here? They're telling the court that even after the fraud was publicized in the Wall Street Journal, even after the Centers for Medicare and Medicaid reported that the Theranos laboratory was a train wreck, there was still $300 million of money on hand. And to prove the point, after Walgreens announced it was terminating their relationship with Theranos, you know how much money Theranos still had? $300 million of cash on hand, meaning that obviously all of these fraudulent aspects did not have much of an impact in the investors from removing the monies that they had invested in the company. That's I think what they're trying to feed the court. Again, nice redacted section, probably talking about the actual guidelines on how it's applied by probation. So to be clear, it is the government's burden to prove the loss and not Ms. Holmes' burden to disprove it. Again, that is true. In criminal courts in the United States, the defendant has no burden. The government is obligated to prove guilt and to prove loss and damages. Next section, gain to Ms. Holmes as an alternative measure. So the defense is giving the judge a different way to evaluate loss. And here's what they say. The appropriate measure of gain is zero. Why? Ms. Holmes never sold any of her equity in the company. Ms. Holmes received a total of $1,546,025.37 in salaried compensation over 6 years from 2010 to 2015. So what they're saying is, judge, if you're going to look at the numbers as the loss amount in this company, what you should consider is zero, because that's how much money she made in her stock, or the $1.5 million she made over the course of 5 years serving as CEO of Theranos. Some which think if the court's going to take that stance or not. Next section, it is if the court accepts the pre-sentence report's calculation of loss, a downward departure is warranted under section 2B1.1. That's the section discussing downward departure in the sentencing guidelines. This is the section they probably talk about the the probation office's calculation. Ms. Holmes objects to calculation of the number of victims. All right, this is important because, again, if you have more than 10 victims, you get an additional 4 points added to your sentencing guidelines score. They're arguing at this point that the guidelines do not allow a district court to estimate the number of victims to enhance a sentence. Yeah, that's true, but I'm sure the court can add to 10, and just between us, 7 of these people testified at her trial. So there's 7. If the court determines there are 3 other people, they get that enhancement. The defense, to their defense, has alleged that in fact there were only 7, not 10, which means the court should not add the 4 points that I presume the probation office has included. Because I included it. All right, Ms. Holmes should not receive an increase for her role. And here's why. 3 pages of redacted documentation is exactly why she should not receive that. The basic gist is she reconstituted the board as soon as they determined there was some sort of fraud as their position. The scientific and technical advisors were brought on board. New experienced staff focused on compliance and quality controls were added. New experienced laboratory directors were told to turn over every rock and make things right. Openness with the scientific community happened. This one's interesting. Let me get through that section. Here it is. Ms. Holmes' recognition, acknowledgement, and assumption of responsibility of her mistakes as Theranos' CEO was central to her reform efforts. She took public personal responsibility for Theranos' failings as early as April of 2016. She told Maria Shriver, "I feel devastated that we did not catch and fix these issues faster." And when asked directly by Ms. Shriver what she had held herself responsible for, Ms. Holmes said, "I'm the founder and the CEO of this company. Anything that happens in this company is my responsibility at the end of the day." She did the same thing in her SEC summary before her indictment in this case, basically saying that, again, she's accepted responsibility. She tried to fix it when she found out that things were going wrong. She tried to implement changes to make things better. It just didn't happen. Excuse me. Therefore, Judge, you should not hammer her as a leader, organizer of this fraud, which is pretty much what the probation office, I promise you, has scored her as. Let's go to section 4 here. 18 USC 3553, again talking about sentencing, supports substantial leniency for Ms. Holmes, and here is why, they say. The court must make an assessment of what sentence is reasonable based on all factors, including the nature and circumstances of the offense and history and characteristics of the defendant. True. The purpose of sentencing, including the need for deterrence and to protect the public. Also true. Kinds of sentences available. Absolutely true. The sentencing guidelines required. Excuse me. Any relevant policy statements issued by the Sentencing Commission. Yes, that is accurate. And the need to avoid unwarranted sentencing disparities and the need to provide restitution to any victim of the offense. All of those are literally a recitation of what 3553 says the court is supposed to consider. I promise you, Judge Davila knows this inside and out. But again, to the defense credit, they're obligated to bring this to the court's attention, and I think they're doing a decent job. And here's what they say the court should consider in representation of a more lenient sentence. Number one, the offense conduct occurred within a unique world of investment startup companies. Ooh, juicy. Theranos and the offense conduct are best understood through the lens of a Silicon Valley startup. That in the environment in which Theranos was founded, in which it was built, and in which investors decided whether and how much to invest, Theranos had massive potential, but its success was uncertain, even highly unlikely in light of the overall odds for startups. And they basically go through the Silicon Valley concept of the fake it till you make it. And all of the people that testify about how they kind of work through it until they solve the problem. And that money invested in these types of companies is invested by serious investors that are very, very smart, and all but the most naive of investors know that there are risks that go along with the potential reward of investment. The defense team also says that Ms. Holmes' conduct should also be considered in the context of this world and filtered through her role as a young, first-time founder without independent business experience. So the court should consider this not only through the eyes of Silicon Valley's fake it till you make it, very risky, hyper complicated world of startups, but you should also consider that Elizabeth Holmes is young, unsophisticated, college dropout, no experience in the corporate world, basically saying that she's not a sophisticated person in her role, and that the court should not sentence her for her offenses in this conduct without taking that into consideration. Let's go down to point number 2. Page 52 for those of you that are following along. Theranos developed innovative technology and provided real services to real customers in furtherance of its mission to improve access to healthcare. And what they're basically saying is Theranos developed real valuable technologies, meaning the hardware, and they're not talking about the Edison machine, they're talking about their little nanotainer, which is the capsule that contained the drop of blood, was something that the hardware actually has a patent on and is functional. They provided software developments, including medical records keeping software, laboratory application, diagnostic tracking, patient and doctor-specific applications, and infectious disease modeling. The company obtained hundreds of patents in the United States and across the world covering many of its inventions. So, Theranos isn't all bad. Good things actually came from this company. That's what they're saying. Let's go to part B. Theranos was on its way to achieving its mission to make health information accessible through its commercial activities. I don't know how the court's going to take this one, but they're basically saying is, if we had a little more time, chances are this really would have worked. You tell me what you think about that argument. I'll tell you how it goes over after Friday's sentencing. C, let's see the next section. Theranos employed hundreds of employees. Yes, it in fact did employ hundreds of employees that spent countless hours and they were paid, and they were brilliant, talented people. And I don't know why that is a reason to power it downward, but apparently we'll find out, hopefully, on Friday. D, Theranos' technology and operations involved scientific and regulatory complexity. This is actually a decent argument too. This is complex stuff. And let's talk about what they say. I'll move down to page 57 for the meat of it. Laboratory testing is highly regulated. Theranos had 2 laboratories certified by authorities in California and Arizona, both of which worked under the authority of federal agencies and the Centers for Medicare and Medicaid. Those laboratories, which were staffed with qualified employees, processed blood samples collected at retail locations such as Walgreens. The vast majority of the 8 million plus test results produced by Theranos were generated on FDA-approved methods, i.e. on commercially available blood testing machines. Ms. Holmes, who does not have a college degree, was not qualified to and did not process patient samples, meaning she didn't actually perform any of this work herself, nor did she determine what methods were appropriate for patient use. In addition to being highly regulated, blood testing is scientifically complex. Laboratory testing has inherent inspections. Try that again. I'm sorry. Laboratory testing has inherent imprecision and imperfections. Even the FDA, the defense says, approves tests that can produce inaccuracies for particular patients at a particular time. Government regulations actually indicate that these tests can be considered accurate even if they differ from a target by large percentages, and they offer some examples here. Excuse me. The criteria for acceptable performance of HDL, meaning cholesterol, is plus or minus 30%. The criteria for acceptable performance of HCG, again, that's for testing pregnancies, is plus or minus 3 standard deviations. Criteria for acceptable performance of platelet count, blood testing, is plus or minus 25% of the target. In other words, even though the Theranos lab results weren't accurate, normal lab result accuracies vary widely, and there is a huge standard deviation, which means the court should really consider this on a much different level, because the commercially available blood testing isn't perfect either. That's what they're getting at. That, I think, is a solid argument. They're going to get some traction on that. We'll see how it goes. Let's go to the next section. Theranos' wide-ranging operations presented both promise and challenges. Yep, and what they say is, additionally, Theranos had a number of other projects that aligned with its broader mission. It was exploring infectious disease testing and tracking projects within international aid organizations, and it put millions of dollars of resources into customizing and improving its devices for potential future military use. I think that is a protective statement designed to overcome the fact that initially Elizabeth Holmes and Theranos came out saying that the military was using the Edison machine in combat zones, which was absolutely false. So the argument was that they were at least trying to do this. So again, it's a little disingenuous, but we'll let the court make a decision on that one. Number 3, the company retained substantial value even after the alleged, let me back up. Yeah, even after the alleged fraud was revealed, they still had assets, even though everybody said this was a fraud. The circumstances show Ms. Holmes to be a founder and CEO deeply committed to the company's mission rather than her own personal gain. And they continue to comment that the court knows Ms. Holmes did not personally profit from the investment. Theranos received, wait a minute. I'm sorry, I'll read that again. I apologize. As the CEO knows, as the court knows, man, I can't get this right. Ms. Holmes did not personally profit from the investments Theranos received, never sold any of her stock. She did, in fact, though, have access to a private jet, wined and dined people, and had a pretty wonderful life hanging out with investors in Las Vegas. So let's take that with a little grain of salt. Number 5, let's scroll down here. Again, a redacted section. Because of their extreme focus on loss, the guidelines are unhelpful in fashioning a fair, just, and reasonable sentence. I think they're going to get some mileage on this. And they basically say, first, this is the type of case where the impact of the loss enhancement means that the guidelines fails to provide reasonable guidance and are of no help when judging to any judge fashioning a sentence that is fair, just, and reasonable. Yeah, again, we've talked about this. The sentencing guidelines, when you get to this dollar value of loss amount, really overstates the severity of the offense. So they're going to get some mileage on that, no doubt about it. I'm telling you now, even the pre-sentence report, I believe, is going to talk about an 11-year downward departure. So their recommendation is 9 years, not 20, and certainly not 80. Second point of order, page 61, for those of you following along. More generally, the loss guideline does not bear the weight the sentencing guidelines gives it. Under 2B1.1, in any modern white-collar case, loss has an inordinate and inappropriate effect on the calculation of the guidelines. The loss tables frequently produce arbitrary and unduly severe sentences for two related reasons. Loss is defined so broadly that it can produce lifelong sentencing ranges for defendants who neither caused much economic harm nor derived much economic benefit from their crimes. And number two, the loss tables enhancements are so large that in practice, they dwarf other potentially relevant conditions. I agree with that, totally. And I think you're going to see the judge is going to agree with that. I know probation agrees with that. And the government even potentially agrees with that to a point. Next section, Ms. Holmes' personal history and characteristics strongly support leniency in her sentence. Let's talk about what they talk about. She is no danger to the public because she has been scored as a potential danger to the public. Ms. Holmes is deeply devoted to her partner and son. That's nice. Ms. Holmes has lived life with purpose to change the world to make it better on a scale large and small. Ms. Holmes lives with kindness, purpose, and selflessness despite significant personal trauma. Friends and family note with admiration that she has handled her indictment and trial with grace and without expressing and indeed discouraging ill will towards the prosecutors who seek to incarcerate her, the media who has vilified her, and those who have been unwilling to stand by her. Okay. Basically, they're saying she didn't say anything bad about the prosecutors. Truth be told, she listened to her lawyers and she didn't say anything at all, except for on the stand. Next, incarceration is not necessary to afford an adequate deterrence to protect the public. Because Ms. Holmes is not a danger to society, she has been out on custody with a perfect pretrial service record for more than 4 years. There is no reason to believe she would commit another fraud or that she will ever be in a position to do so again. Ms. Holmes has readily and repeatedly acknowledged that many mistakes she has made as serving CEO in Theranos in interviews and on the witness stand in front of the jury and to friends and family. Elizabeth understands that she has been lost. Elizabeth understands what has been lost and has suffered the consequences of the offense daily for years in ways large and small. She has been formally penalized for her mistakes in other forms through the administrative state by CMS and the court in connection with her settlement with the SEC, the civil settlement. Ms. Holmes spent her entire adult life building Theranos until its collapse, a personal and public failure she feels deeply. Moreover, this incessant drum of media criticism has ensured Ms. Holmes will be punished for the rest of her life. The court is well aware of the unusually intense media attention on this case before, during, and after Ms. Holmes' trial. The coverage of her as a person is universally negative. The portrayal of Ms. Holmes at best is unflattering, caricature, and at worst, dehumanizingly cruel. In other words, the court doesn't have to send her to prison. She's already been publicly punished in the court of public opinion, in the media. Her life is a train wreck. No one will ever want to do business with her again. That is the basic gist of what that section talks about. It continues on page 66. Ms. Holmes will never be able to seek another job or meet new friends without the negative caricature acting as a barrier. She worries about how the notoriety affects her friends and family. She has suffered a substantial loss of privacy despite her best attempts to stay out of the public eye and to respect the legal process around the case, meaning she didn't go out there and bang her chest in front of the cameras. And incarceration is not generally a deterrent. This is going to be interesting. The fact that they claim incarceration is not a deterrent, how do you argue with that in anything other than to say, are you kidding me? Prison is a deterrent. That's the deterrent we have. The argument that just because she may go to prison doesn't really make much of a difference, because you know what? Her prison sentence can be light anyway. And what they're really saying is, if you want to commit a fraud and steal millions and millions of dollars, it's worth it. That's what they're really saying. Other than that, let's continue. Section 60, page 67 again. I'm not sure what that section is a citation to, but then Part D talks about just punishment and respect the law are not served by lengthy incarceration. I mean, I think that speaks for itself. She doesn't need to go to prison for her to be punished and to have respect for the law. The next section, E, section 3553, again, talking about sentencing, supports a downward variance from the guidelines. And I'll tell you why. Because in February of 2021, the COO of a publicly traded pharmaceutical company was sentenced after trial after a guilty verdict on one count of wire fraud for 12 months in custody. The guidelines range was 262 to 327 months. In November of 2019, a hedge fund trader was found guilty after trial of overinflating the hedge fund's assets by $100 million, and he was sentenced to 40 months imprisonment. The sentencing guideline range was 161 to 210 months. In November of 2018, an individual who was convicted of securities fraud after trial was sentenced to a term of 6 months imprisonment after the government had calculated a guidelines prison sentence of 63 to 78 months. In October of 2018, a former State Street executive was convicted of securities fraud. He got a sentence of 18 months. The government calculated his sentence somewhere between 14 and 17 years. In October of 2018, you get the point, a serial fraudster who committed additional crimes while awaiting sentencing after his federal guilty plea was sentenced to 72 months when the government calculated his guidelines between 188 to 235 months. And they continue basically citing all of these other white-collar offenders, corporate fraud types that had huge or very large sentencing guideline score that basically get a slap on the wrist. Ergo, judge, you should also downward depart hugely, so she just gets a slap on the wrist. That's what this says. Section F, 3553 does not counsel in favor of incarceration. I'm going to read a section here to you. Let's see here. The potential need for restitution in this case should not weigh in favor of incarceration for at least 3 reasons. First, this is not a case where the restitution would require to return vulnerable victims to their prior status. Again, the Theranos investors were required to represent that they were sophisticated, that they understood the limited operating history and uncertain future of the company, that they could afford to lose their entire investment without suffering financial harm. Secondly, although she did not personally benefit from the investment, Ms. Holmes took dramatic and meaningful steps to give value to her investors following the Wall Street Journal investigation, including several at her own expense and risk. And let's see where number 3 is. Ms. Holmes does not have the assets to pay a restitution to any investor. So those are 3 reasons. Number 1, these guys are not vulnerable. These are hugely rich people in major corporations that invest in these types of companies in order for them to get the multiple. And what that means is you're not looking for 10% return or 20%. You're looking for 3 times your money, 5 times your money, 20 times your money. That's why you invest in these types of things. Now, of course, you don't invest in them when you're provided information that leads you to believe that this is a total fraud. But again, the concept is well taken. And Elizabeth Holmes doesn't have any assets to pay any restitution. So really, why send her to prison, Judge? Page 72. Let's go on. G, Ms. Holmes' capacity to do good supports a sentence that in part orders Ms. Holmes to engage in significant community service. She has the capacity to she has the capacity to perform community service. She's done so after she got convicted. She's done wonderful things. And Judge, you're better off letting her just go out there and do wonderful things. Continue to work with volunteering and supporting several sexual assault organizations. That is much better than sending her to prison. That is the argument. Okay, that is the extent of what the government is arguing in their brief. What I'm going to do is I'm going to stop this particular video. For those of you that want this deep dive into what these sentencing memorandum says, the next video is going to focus on the government's brief and what their response is to Elizabeth Holmes' defense team and what they believe the court should take into consideration. So if you've liked this video, albeit extremely long and intensive, please give me a thumbs up. If you've got questions and comments about it, leave them down below. And please, if you haven't already done so, subscribe to our channel. We'll be back with part 2 of this in a moment regarding the government's calculation. See you then. Hi, everyone. Pete Sartes for the Lawyer You Know, and welcome back to the second segment of the Elizabeth Holmes sentencing memoranda. If you joined us for the first segment, we talked about the defense 80-something page sentencing memorandum and what, in essence, the defense is asking the judge to do on Friday in regards to sentencing Elizabeth Holmes. In response to that sentencing memorandum, the government has filed their own sentencing memorandum, and I will share that with you all so you can follow along with me as we dive into this memorandum, this reply to the defendant's motion for the court. Now, for those of you that are following along and are interested in the actual docket itself, I'm putting up on the screen. It is document number 1643 in the docket, filed on November 11th. Interestingly enough, the defense's sentencing memorandum was filed the day before this and is 80-something pages long. I give the government's lawyers credit for being able to produce this memorandum so quickly and get it filed literally the next day. So obviously they've been preparing for this. They've thought about how they're going to structure it. And this segment is going to focus on what the government is going to ask the judge to do on Friday during sentencing. So let's talk about where the government starts. The government has obviously their table of contents. They have their table of authorities for the court, citing all of the case law and the statutes that they believe are relevant. But in regards to where the discussion starts, here's where the government goes. And they start by saying the sentencing guidelines appropriately recognizes that Holmes' crimes were extraordinarily serious, among the most substantial white-collar offenses Silicon Valley or any other district has seen. According to the pre-sentence investigation report, they yield a recommended custodial sentence beyond the statutory maximum. The factors set forth in 18 U.S.C. 3553, which is the sentencing statute, notably the nature and circumstances of the offense, the need for the sentence to reflect the seriousness of the offense and promote respect for the law, and the need for both specific deterrence and general deterrence, demand a significant custodial sentence. With these factors in mind, the government respectfully requests a sentence of 180 months in custody. The court should also order Holmes to serve a 3-year term of supervised release, pay full restitution to her investors, including Walgreens and Safeway, and pay the required special assessment for each count. Let's talk about that for a second. The government basically is saying that this is a very serious crime where the sentence that is recommended by the pre-sentence report is off the charts. We've talked about that many, many times. Based on that, the government is conceding that there is an overstatement of the severity when you look at 20 years or obviously things beyond the statutory maximum. So they're asking the judge to put in a sentence for Elizabeth Holmes of 180 months, which is 15 years in prison. In addition, they want 3 years of supervised relief, which is basically a term of probation, and full restitution, which is kind of a big deal because not only are they is the contrary opinion to the defense that she has no money, therefore she shouldn't have to pay anything. The contrary position the government puts out is not only should she pay all the investors back, but she should also pay Walgreens and Safeway back for all the monies that they obviously invested in Theranos or invested with Theranos during the term of this fraud. Now, the special assessment is kind of not a big deal, but it exists. The federal government requires every convicted or defendant that pleads guilty to an offense to pay a $100 per count of conviction special assessment. That's $400. Honestly, I don't know what the purpose of the extra assessment is for, but it's in every federal case it exists. So if you've pled guilty or if you have been convicted by a jury or a judge, frankly, of a specific felony count, it's $100 per felony count. So let's kind of move into the meat of what the government is arguing. I'm just going to go down the line and give you the basics. The offense conduct is where they start their discussions. The investor fraud. And the investor fraud from the government's perspective is this. After her fraud, meaning Elizabeth Holmes, was revealed, she lied and concealed at trial. She blamed her COO and longtime boyfriend, her board, her scientists, her business partners, her investors, her marketing firm, her attorneys, the media, everyone that is but herself. This is not only something that the government has pulled from the trial itself, but it's a direct contraposition to the defense memorandum, which basically says Elizabeth had all of these people surrounding her, all these experts, so they were far smarter, more educated, more experienced than she was. Therefore, they have a spot to blame that is beyond her culpability. To continue, she also puts patients at risk. As money was drying up, she went to market with an unproven and unreliable medical device. As her lab director kept encountering issues with Theranos' device and test, she chose PR and fundraising over patient care. Holmes speaks eloquently about her desire to innovate and improve healthcare. She has demonstrated a strong work ethic, charisma, and ambition, but she is blinded by that ambition. Her reality, distortion field put, and will continue to put people in harm's way. She stands before this court remorseless. She accepts no responsibility, quite the opposite. She insists she is the victim. This is kind of a big deal for the government to set off right off the bat to the court. And what the government is basically telling us, A, she has not accepted responsibility for this, so therefore she should not be given the credit that the government is saying she deserves for being a nice person and for multiple times saying that she was a CEO and was in charge in news outlets or when she was doing press releases. Other than that, they're trying to counterpose the 130 character reference letters that Elizabeth Holmes' lawyers have put into their sentencing memorandum. And at this point, they're saying, yeah, she may be smart and she may have a strong work ethic and all those things may be true. But at the end of the day, it doesn't matter because she put people in harm's way. And when things were falling apart at the company, as opposed to getting the company on track, she focused on marketing. She focused on making sure that the company survived, even to the detriment of those around her. They actually walk through the misrepresentations that they believe Elizabeth Holmes has made, and we start that here on page 3, and they outline these for the court. A few examples of misrepresentation made by Ms. Holmes to Theranos investors. In April 2010, Holmes emailed executives of Walgreens with reports favorable conclusions about Theranos' technology that were emblazoned with a logo of large pharmaceutical companies, Pfizer, GlaxoSmithKline, and Schering-Plough, which is now Merck. And Holmes described the attached report as 3 independent due diligence reports on Theranos systems that were from those companies. These were fraud, and there's no other way to say it. The executives of these companies testified that they had never authorized Elizabeth Holmes to use their logos. They had never allowed Theranos to make the representations that the company somehow backed the product. So ultimately, these are frauds. There's no other way around that. And I think that's the government's point in this section. Holmes continued to send the doctored Pfizer report to investors that she got back in 2009, 2010 time period to investors throughout 2014 and 2015. Next, in 2010, Holmes told Stephen Bird, the then CEO of Safeway, that Theranos was cash flow neutral and project revenues for 2011 of $223 million, when in truth, Theranos revenue was steadily declining from approximately $2.8 million in 2009 to less than $600,000 in 2011. For those of you that may not understand the concept of cash flow neutral, it means they basically are flat. They're producing monies that are not changing year over year. Obviously, not true. December of 13, Theranos had historically earned, let's do this, over $200 million from work with the Department of Defense and pharmaceutical companies, when in reality, Theranos had never earned more than $10 million from both sources combined. In August and September of 2013, internal Theranos scientists and the then lab director, Dr. Adam Rosendorf, warned Holmes that Theranos' proprietary device was not able to reliably test patient samples. Holmes reviewed and approved an article in the Wall Street Journal claiming Theranos' device could run 1,000 lab tests with more accuracy than conventional methods. And Holmes shared that article with investors. As we know from the trial and from talking about this, the Edison machine apparently could only run blood samples accurately for about 12 different blood disorders. That being said, that's only when it worked, not all the time. 2013 and 2014, the government continues. Holmes repeatedly told investors that the Department of Defense was using Theranos' proprietary analyzer on medevac helicopters in the battlefield or to treat soldiers in Afghanistan or Iraq. In truth, the Department of Defense never used Theranos' device to clinically treat patients, nor did it ever move out of initial testing phases. I think, and I don't know, I should find out if Judge Davila is a veteran. But if he is, this is going to burn him, because I think we talk about stolen valor. I'm a veteran. I served 10 years in the Army. For those of you that might not know that, we kind of take that seriously. It burns us. And when you use the military and you kind of tout the wonderful things that you're doing along with the military when it's absolutely false, I believe anyone that has a military background is really going to get a sour taste in their mouth about that full representation. So as we continue, I'm going to move down to page 5 if you're following along. While Holmes was publicly touting Theranos as a revolution in healthcare, she and Balwani quietly and repeatedly acknowledged the dark reality within Theranos to each other. For example, they texted. And what the government has done is you will see all of the texts line by line that were admitted during the trial that talk about how, frankly, Theranos is a fraud. And those are discussions between Elizabeth Holmes and Sonny Balwani. And they're all here line itemed for the court. Let's continue down to page 7. Holmes' fraud was spectacularly successful. At the peak, she was one of the richest and most celebrated women leaders in our country's history. By the end of 2014, Holmes' share in Theranos was valued at more than $4 billion. She took home hundreds of thousands of dollars in annual salary. She traveled in Theranos' private jet. She and Balwani ruled Theranos from a $15 million mansion in Atherton. She donned the cover of Fortune, Forbes, Glamour, and the New York Times and Style magazine. She dined at the White House. She gave commencement addresses at Pepperdine University. She joined the Board of Fellows of Harvard Medical School, and at the peak of the fraud was named by Time as one of the 100 most influential people in the world. And the government has done a great job there of expressing to the court what Elizabeth Holmes was doing at the peak of the fraud, and that I think is important, at the time where they're lying to investors, they're purporting information in public streams of media that are just simply not true. And I think that that is going to affect the court, I think, quite profoundly. Now, do I think the court is going to issue a sentence in the 15-year mark? Initially, before today, I would have thought the answer is yes. I've said it multiple times. I really thought that the court was going to be in a place where they're going to sentence closer to that 20-year mark. But now with a pre-sentence report, and we'll talk about that, that is really more in the 9-year range, a lot of judges are safe following the probation recommendation. So we shall see if Judge Davila goes against the grain and uses a number of the issues that the government is citing here in order to justify a sentence within the guideline, but higher than the recommendations of probation. All right, let us continue on to page 8. Between 2010, when she induced Walgreens and Safeway to invest based on false pharmaceutical company endorsements and fantastic revenue projections, and March of 2015, Holmes raised hundreds of millions of dollars. As the pre-sentence report notes, 730,840, let's try that again, $730,840,309 came from Series C1 and Series 2 investors who invested subsequent to Theranos Public Relations published in 2013. That C1 and C2 investment of $700 and something million does not include an additional $70 million invested by Walgreens and Safeway on account of convertible promissory notes, and $3 million invested by director George Shultz, who testified in the civil litigation action against Holmes. So the government is setting up the loss calculation. $730 million of investors, not counting the 70 from Walgreens and Safeway, not counting $3 million from Greg Schultz. That's just kind of adding these up for the court. Now, let's continue. The impact on patients. This is important because the government was criticized, especially during Elizabeth Holmes' trial, not so much during the Balwani trial, that they just simply did not put a lot of stock in impact on the patients. There were not that many patients that testified. There was not a lot of evidence that really regarded the patients. And I think they caught a lot of grief from this, from the patients, basically saying, are we just valueless here? Is it all about money? Does it not matter that our lives were turned upside down? So let's talk about some of the details the government gives the court for its consideration. Merrill Ellsworth sought a PSA, which is a prostate-specific antigen test, from Theranos in advance of an international trip. Theranos reported that Dr. Ellsworth's PSA levels to be extremely elevated compared with previous results, a change that could have indicated prostate cancer if accurate. Dr. Ellsworth's next test from Theranos showed normal PSAs. The third test from Theranos once again dramatically elevated, but subsequent tests returned normal results. It turns out that two unexpected elevated PSA results from Theranos had something in common. They were both run on the Theranos proprietary system, meaning the Edison machine, whereas the normal results had been generated by traditional FDA-approved methods, meaning the Siemens machines that Theranos had. Second patient, AT, suffered from atrial fibrillation, we call that AFib, and her doctor instructed her to obtain a PT-INR from Theranos. AT told the government investigators that she had adjusted her medication in response to the erroneously low PT-INR values. And she would have been at risk for internal bleeding, and which is a common complication of AFib. Theranos' own employees weren't even immune to these questionable results, e.g., who was a Theranos phlebotomist, meaning somebody that draws blood, who had been on blood thinning medication for years due to history of blood clots, went to Theranos for a PT-INR test. Her results came back markedly different from her usual levels. Her doctor adjusted her medication in response. Several Theranos patients received erroneous HCG tests which provided inaccurate information about the status of their pregnancies. Brittany Gould, who actually did testify, had a dramatic drop in her HCG value, which strongly indicated that Miss Gould was having another miscarriage. But confirmatory testing by Quest Diagnostic Imaging indicated that a viable pregnancy was there and that Miss Gould went on to deliver a healthy baby. In May of 2014, a physician called Theranos about the HCG results. And in response to that, Theranos' test values, that patient's doctors had been discontinued pregnancy medication and told to get ready for their next menstrual cycle. The purpose of this, obviously, to show the amount of personal impact that real life people experienced at the hands of Theranos and its leadership. Let me move over to page 12 and we'll continue this. In March of 2014, records indicated that nearly 26% of quality control checks on the TSPU resulted in failures and inaccurate results, and that is the Edison machine. Theranos' PSA test failures quality controlled nearly 30% of the time. Some other tests failed more than 50% of the time. When the Center for Medicare and Medicaid Services inspected Theranos at a later the summer of 2015, CMS put Theranos on notice of multiple and recurring time periods across all analysis tested of abrupt shifts in quality control. And based on that, Theranos test results were voided on every patient that had ever been run on an Edison machine in the clinical lab. This is a direct counterpoint to the defendant's motion where they talk about, well, you know, all these other tests, all these other blood tests, well, they have a failure rate too. They're not always accurate. The government's counterpoint is, yes, but you guys failed more than 50% of the time, up to the point where they actually removed these test results from patients' files. Then the government continues to talk about the cover-up. In April of 2015, Holmes learned that a Wall Street Journal reporter was working on a negative story about Theranos. Unable to dupe that reporter, they hired David Boies to try to get him to drop the story. When they failed, Holmes personally appealed to the owner of the Wall Street Journal, who was a significant investor in Theranos, to quash the story. In June of 2015, she had a man sit all day outside of Erica Chung's workplace to serve a letter from Boies Schiller Flexner LLP, which was their law firm, threatening her with legal action. She also had Boies Schiller lawyers surprise Tyler Schultz at his grandfather, who was George Schultz's home, to have him sign an affidavit identifying himself as a source of the reporting to the Wall Street Journal. Furthermore, on October 15th of 2015, when confronted on Jim Cramer's Mad Money with the Journal's claim that the Edison machine could only do 15 out of 240 tests, Holmes falsely stated that every test that we offer in our laboratory can run on our proprietary devices. On October 21st, 2015, she falsely stated at a public conference that Theranos never used commercially available lab equipment for finger stick-based tests. We know that is false. We also know that this is exactly the counterpoint to the defense's memorandum, which basically says, oh, not Elizabeth Holmes. She was a college dropout with no corporate experience. Sonny Balwani was in charge of all this. Everything that was done because he told people what was going on, or he told Elizabeth Holmes what to say. A direct counterpoint, this is Elizabeth Holmes speaking and perpetrating a fraud. All right, let's continue. Here's the actual sentencing guideline calculation. I've done one, probation has done one, the defense has done one, the government has done one. I think everybody agrees at this point that the total offense level is 80 years. It's off the chart. 20 years is the statutory maximum. The government has recommended a 15-year sentence. The PSR recommends that the court vary from the guidelines and impose a sentence of 108 months. That is 9 years. Let me confirm that for y'all just to make sure I'm right. And the way we do it is 108 divided by 12. And here we go. That's 9 years. So that is the pre-sentence recommendation for a sentence for Elizabeth Holmes for everything that's happened. The government believes that some enhancements absolutely should apply. First is the loss amount. Let's just initially say that loss amount is a point of contention. I think everybody agrees with that the loss amount of more than $550 million does overstate the severity of the offense. But regardless, the government wants the judge to consider it and to use it. And what they've done in page 17 of their brief indicate that Mosley invested $6 million, RDV invested $100 million, PFM invested $96 million, and although $43,000 was returned to PFM in a settlement with a civil lawsuit, the rest of this money is in fact losses associated with the fraud. Holmes raised $730 million from investors in the Series C round, the Series 1 and 2 rounds, including Mosley, the DeVos family, which is RDV, and PFM. They too lost the entirety of their investment when Theranos declared bankruptcy through an assignment for the benefit of creditors. The trial also includes evidence that Safeway invested $30 million and lost it, and Walgreens invested it and lost $40 million. When you add all that up, the government's representation is that's more than $550 million. Even taking into consideration the assumptions most favorable to Elizabeth Holmes, there are $237 million to $273 million of valuation loss by investors. That is a counterpoint to the to the defendant's attempt to try to get the court to use a different calculation method as opposed to the loss amount of the amount of money intended to be lost or the amount of money at risk, to use the amount of money that was actually lost by individual investors. This is important because what the government's saying is under no way, shape, or form is the loss amount less than $150 million, which is still a 30-point enhancement. So even if $550 million isn't the number, $150 million is the absolute minimum number. So therefore, a sentence much higher than the defense and probation is warranted. The next enhancement, offenses involving 10 or more victims. The guideline provides for a 2-level increase if the offense involves 10 or more victims. The pre-sentence report correctly finds that this enhancement applies. Under any measure, there are more than 10 individual entities that have sustained a loss as a result of Holmes' fraud. All right, let's continue. The next section, defendant's conduct creates a risk of serious harm to Theranos patients. That is also a 2-level enhancement that the government believes it should be given, saying that Elizabeth Holmes' conduct created a significant risk of death or serious injury as a result of misdiagnosis. An inaccurate test result could cause a patient to undergo an unnecessary treatment that could harm them or forego a necessary treatment that could save them. In other words, the government needs not show actual injury to any particular victim. Under Ninth Circuit law, a defendant cannot escape this enhancement by claiming ignorance of the risk created by their conduct. Moreover, the evidence shows that Holmes was fully conscious of the risk caused by Theranos' unreliable test. And again, counterpoint to the defendant's perspective in their brief that you actually have to find people that had harm and you have to actually prove that there are more than 10 of them. We'll see what the judge does on that. I think that there's going to be a lot of argument about the loss amount. I'm not sure how much fight there's going to be over 10 or more victims. We'll see how it goes on Friday. The government continues in their brief. I'm on page 24 for those of you following along. The next thing that they believe is relevant is Holmes' treatment of Theranos patients, and that should be counted as relevant conduct. This is important because Elizabeth Holmes was not convicted of any patient-related conduct, but the way the sentencing guideline is set up, a court can take into consider any relevant conduct that was involved in the fraud. This is one of them. So Holmes acquitted on those counts relating to her scheme to defraud patients does not prevent the enhancement from applying. That is true. We'll see what happens. Role in the offense. Again, this is whether or not there are 5 or more participants or whether she was a leader or organizer. The defense believes that she is not either of those things because everyone else was smarter, more educated, more experienced than her, and all she did was take the opinions of others and keep the company moving forward. I believe you're going to see that Elizabeth Holmes was a leader or organizer. Here, this is what the government says. First, there can be no dispute that Holmes was an organizer and leader of the criminal activity because she was, in fact, the person responsible for making all of the decisions. Can't argue with that. Let's see B. Holmes' fraud was otherwise extensive. Another reason for the court to give this enhancement because the fraud was extensive, meaning it was very complicated and it was very detailed and it was frankly difficult to detect. So that is what the government is arguing generally. Again, I think you're going to see the court agree with a lot of these things. The legal standard is the overarching goal of the sentencing court is to impose a sentence that is sufficient to reflect the seriousness of the offense, promote respect for the law, and provide a just punishment, to afford adequate deterrence and to protect the public, and to provide the defendant with needed education or vocational training, medical care, or other correctional treatment. That is a slam on Elizabeth Holmes for not only what's happening with her pregnancy, but also in counterpoint to the defense's position that she should not go to prison at all. And we'll see, I think we're going to see a lot of argument on that. The government talks generally about a need to avoid unwarranted disparities. And this is important. There are some other smaller arguments in here that were raised by the government talking about properly calculated ranges, protecting the public. And those all I think you understand because we talked about them generally when we did the defendant's argument. But at this point, let me take you down to page 38. The government actually outlines, let's get there, all of the white-collar criminals that have been sentenced, that have cases similar to Elizabeth Holmes, and you're talking about sentences of 120, 150, 204, 144, 300, 264, 100 months, all of which have loss amounts substantially less than Elizabeth Holmes, 40, 50, 70 million, and up to 600 million to $1 billion. So the court is going to have to consider how other defendants have been sentenced throughout the country, especially in the Northern District of California, and kind of balance Elizabeth Holmes' sentence with those sentences. The government finally talks about restitution and fine, and what they say is they want Elizabeth Holmes to pay $803,840,000 to Safeway, to Walgreens, to the Theranos investors, and to George Schultz. The government also says even the pre-sentence report shows that Holmes has modest assets outweighed by a $450 million loan for the SEC settlement. She has legal fees in excess of $30 million. And the pre-sentence report notes that Holmes's family appears to have substantial assets and that Holmes is managing her affairs to avoid subjecting their assets to any judgment in the case. The prosecutor wants the court to consider all that and to question how this is happening, because Billy Evans' assets are not collectible in this matter. Her mom and dad's assets are not collectible in this matter. They can't even be used to determine whether or not she has the ability to pay. But at this point, I think the government recognizes that she'll never pay any real restitution amount, nowhere near this money. But they want the court to look into how the family of Elizabeth Holmes is moving money around and avoiding doing things like getting married to avoid Elizabeth Holmes having assets. All right, Friday, 10 o'clock in the morning Pacific time is when Elizabeth Holmes' sentencing is scheduled for. It is going to be the entire day. We'll do a report as soon as I have some basic information. At that point, we're going to know, does the government side with the probation office? Does the government side with the defense? Does the government side with the prosecution? What is the sentence going to be? I will keep you posted. But for now, thank you for watching. As always, if you enjoyed the episode, this particular two-part episode, give me a thumbs up. If you've enjoyed this series, please subscribe to our channel, watch the rest of the content we have. And as always, leave me questions and comments below.